We also have an email question to start us off this evening. It comes from Rick. Who is able to sue for negligence, and are there any different rules depending on how you were injured? A great question to start us off. Brian, Lance, who wants to start us off from that question tonight?
I mean, I'll hop in and then toss it over to Lance. There's a few different types of personal injury cases we deal with, whether you're hurt on someone's property, a slip and fall, trip and fall type case, whether a defective product hurts you. We have had a case where a battery exploded or something malfunctions and hurts you, or if you're in a car wreck because somebody does something wrong. So there's different standards for each type of case, in addition to malpractice cases that some of the attorneys at our firm handle. So Lance can probably walk us through, what the standards are, whether it's a car wreck where someone runs a red light, or what the standards are for if you're hurt on someone else's property or by a defective product.
Sure, and the simple answer to start off with, who can sue, and the answer there is pretty much anyone, except with the exception of if you're dealing with a minor or someone who's legally incompetent. They cannot personally bring the suit themselves. You do have to be 18 years old and be competent in order to actually file the lawsuit. But even those folks still have claims that they're able to bring through, a parent or some sort of guardian or somebody appointed by the court to bring those claims for them. With respect to the different types of claims that Brian alluded to, the general standard is that you are allowed to sue folks for injuries that are caused by their negligence. Negligence is the failure to use reasonable care. And in every different type of case that he mentioned, there are different things you look for in terms of what is reasonable care. But overall, what you're looking for is, did they fail to use reasonable care? So in the auto accident context, it's did they run a stoplight or crash into you while you were sitting still, not paying attention to the road in front of them. In the premises liability case, it's did the store or the business allow some sort of transitory foreign substance, some water or banana peel or something like that to remain on the floor after they had an opportunity to find it and they still didn't pick it up and clean it up, so that it created some sort of hazard that you tripped and fell on or slipped and fell on and were injured. And that's kind of the basics, but yeah, pretty much anyone who's sued by someone who's done something that they shouldn't have, someone who's injured by something that they didn't do or did do that they shouldn't have, they have the right to sue for damages that are caused by that.
How do they prove negligence? I know you were just talking about that a little bit, Lance, with, if they ran a stop sign. Do you have to have a police report or something, some documentation to prove that, in that situation?
Well, the police report typically is not admissible to prove anything at trial. I mean, there's very few things where you can use it. Most of the time it's considered privileged because Florida law requires you after an accident to give a statement to the police. And because of that, the Florida legislature has said that anything you say to the police officer following an accident is not actually admissible at trial. And the officer himself very rarely actually witnessed what happened, so he has no first-hand knowledge of what took place and who did what wrong. So the police report is good. It gives us basic information about who the parties are, who witnesses might be, but normally what you're looking for to actually establish and prove that there was negligence is the testimony of the folks who were involved. Some cases there's a presumption perhaps of negligence depending on the facts, but most of the time you're looking at either eyewitness testimony or the testimony of the parties to establish what took place, and that's how you prove that the at-fault person did something wrong, and that's what led to the crash.
We're talking about police reports, and just while we're on the subject, maybe you can answer this, Brian. Should you call the police? When's a situation when can you sort it out with the other party? I've done that before where I've said, hey, we're all right, hey, we can sort it out just between us, and I paid for their damages, and they've helped me out. Is that a good way to go, or would you advise against that? Is it better to always involve the police and have some written documentation of it?
I would always involve the police because at a minimum you're going to have a written record of who the other party is, where they live at, who their insurance company is. It doesn't happen that often, but occasionally we get a crash report where someone gives the police insurance that's either expired or no longer valid, and the police officer has no way to verify that. So we are able to, with the crash report, we have that person's contact information, we have the vehicle owner's contact information, and we're able to reach out to those people and verify whether or not they have insurance. So at a minimum, you will be inconvenienced by the police taking 10 or 15 minutes to get there, but it's worth it to have all the information accurately reported, and the other party, the at-fault party, let's say they run into the back of you, you will be surprised what types of things they may tell their insurance company that they wouldn't tell a police officer. Now, insurance companies do use police reports, although they are not admissible evidence, because it's what both parties should be telling the police officer that are truthful about what happened. So it is important to call the police and have everything documented, and then the police writes up what everybody tells them. So although that report is not admissible, everybody uses that as a basis for what happened. Now, police reports are not perfect. There are typos. Sometimes it's a he said, she said type of scenario, but at a minimum, you at least get that there is a dispute on the crash report.
So if there is no police report, let's say you guys sort it out, hey, I'm no harm, no foul kind of thing, and later they try and come back. Maybe you exchange telephone numbers, you did exchange insurance information. What if they come back and say, hey, you actually did, my back hurts, you actually did hurt me, and can they actually do that if there is no police report?
Absolutely.
Wow.
The police report doesn't, again, it's not even admissible at trial.
Yeah.
It's the shorthand acknowledgement of everybody that's involved, and it helps. It certainly does, and we like to have it because it gives us the information we need. We know who to contact. It contains a little synopsis typically of what happened, and if everybody's in agreement with that and doesn't fight about it down the road, then most of the time we're going to rely on that pretty heavily in the pre-suit, meaning before we filed a lawsuit type setting, and so is the insurance company. But whether or not an accident report was made, I mean, in some instances, yeah, it could make a difference. You may have the at-fault party saying, no, that never took place. I don't know who this person is, and disputing that. But nothing about whether or not you made the crash report is determinative of whether or not you can come back at some point in time and make a personal injury claim down the road.
So definitely call the police if you are in an accident, even if it's small, even if it's something, it could be a little tiny fender bender, maybe you don't think you need to call the police on that. You recommend definitely calling them just to have that documentation, right?
Yeah, again, even if there are no injuries, even if it is a minor fender bender, you still want everything documented. And with respect to injuries, and it's more for older people, but sometimes on the minor car wrecks where there's not significant property damage, you notice the next day your back and your neck are feeling worse and worse and worse, and it's because your body's thrown in an unnatural motion even though there is minimal property damage. So you might deny medical treatment on the first day and not go to the hospital the second day, but after a couple of days you notice that there's something wrong with your body and you need to get it checked out. So even though you don't have symptoms, you're not in pain at the scene, you should still document it just in case a day, 2 days, 3 days, a week later, you start to notice something and you need it documented.
Brian, you were talking about, hey, if you are injured in an accident, sometimes you don't feel it that first day. How long do you have to go to the doctor before it turns into, well, hey, that wasn't really part of your accident, right? Where it could be thrown out and said, hey, that isn't really related to the car accident that you got into.
Well, I'll answer that in two parts. If you've heard Florida is a no-fault state, that means everyone is required to carry the personal injury protection benefits that are available to anyone who's injured in a car wreck as long as you get medical treatment within 14 days. If you do not get medical treatment within 14 days of a car wreck, you don't have those benefits. That does not mean you can't go get medical treatment if you were injured in a car wreck. It just means you miss out on those benefits. But the best argument that defense attorneys and insurance companies make is if you were hurt, then you would go get treatment sooner rather than later. So there is no clear-cut line, but if you wait a week or two, that's explainable. If you wait 6 months and then go get checked out, an insurance company or defense attorney will point to something else to say that is the cause of your accident or cause of your injuries as opposed to a collision, especially if it's a minor property damage car wreck. So it's better, I tell all of my clients, it's better to get checked out and make sure you're okay and get the medical treatment you and your doctors think are necessary. If you're fine, if you have no symptoms, then there is no reason to go to a doctor and incur a bill that you don't need. But if you are having issues, you should go get checked out.